welcome. Good morning from my side. Thank you very much for having given me the possibility, the opportunity to organize this together with you within the framework of the European Notarial Network. It wouldn't have been possible to organize this without Alice Perscher, and obviously it wouldn't have possible, that needs to be said, without Stefan Matic, because he did the main work for organizing this, so thank you very much for this. So we start immediately, and as you can see, I'm going to talk about the relationship with national certificates and the European Certificate of Succession. And I actually prepared some slides to talk about the European Certificates of Succession in general, but I will very briefly address only some questions which I think are important, because we are running out of time otherwise. It is better to be brief with regard to this. Just I want to remind you, because we will be talking about these effects, of the European Certificate of Succession. As you all know, under Article 69, the European Certificate of Succession has three basic effects. So it's the presumption of accuracy as the first effect. The second effect is the public faith effect, and the third effect is the legitimizing effect. Presumption of accuracy actually means that all the elements established in the European Certificate of Succession are presumed to be correct, which means also that the person indicated in the certificate is presumed to be the heir, the legatee, the administrator or executor of the estate, and it is important to say that he or she is presumed to have the powers and rights that correspond to this status. And the second effect is the public faith effect. It regards third parties which may rely on the European Certificate of Succession unless they are in bad faith or ignorant of the inaccuracy for gross negligence, both when they pay to the person who is indicated in the succession certificate, as well as when they acquire from that person. And the third effect is the legitimizing effect. As you all know, it is a valid document for recording in a public register in one of the member states. That does not mean that it is sufficient, but for showing, demonstrating the status of an heir, of a beneficiary, it is sufficient, and the member state may not require authentic instruments or decisions or any other documents that demonstrate this status, because the status is demonstrated for that purpose by the European Certificate of Succession. With regard to this first presumption of accuracy, I wanted to say that it is a presumption. So that means in theory and also in practice it must be rebuttable. Just the regulation does not say anything about this rebuttal. So what we know about the rebuttal, at least what we think we know, is that it must be rebuttable in front of the authority where the European certificate is used. And it is generally said according to procedural law, applying in that state where the European Certificate of Succession is used. So if you use it in Poland, it should be rebuttable according to procedural law in Poland. And this rebuttal needs to be started by one of the parties who are affected by the European Certificate of Succession. But what we can see in practice, and I refer to Germany, is that European certificates are rejected by land registers or offices on the basis we do not believe what the European Certificate of Succession says, because it says that a certain asset of the estate goes directly to one of the co-heirs, and please show us that this is correct. Even if it is in the European certificate, we do not believe. So we reject unless you prove that this is correct. Obviously, this is an inversion of the presumption, but that happens in practice. And it has happened at least 3 times, because we know of 3 published sentences on this in Germany. This is one practical problem. And another practical problem is that for the purpose of releasing assets in a member state, it is very often not sufficient to just show the status of an heir or beneficiary. So if you go with a European certificate of succession to a French bank, for example, the bank will tell you, no, I do not accept this. It's not sufficient because according to our law, we need a public registration of a foreign will. So if the European certificate of succession is based on a will drafted outside of France, this foreign will needs to be translated into French, registered, and together with the European certificate, the bank will grant you access to the assets, but the ECS itself will not suffice. And the Cour de Cassation decided on this question, whether it is compatible or not with the EU regulation, and it basically says this is done for tax purposes, so taxes do not form part of the scope of application of the regulation, so it is compatible. We may ask this in addition to the European certificate, also because the European certificate is not an enforceable title. Okay, so let's jump this first part and now get to national certificates in cross-border situations. So can national certificates actually be applied in cross-border situations? Yes, in generally, this cannot be denied because there is no mandatory use of the European certificate of succession. This is just an optional instrument. You can apply for the European certificate of succession and in parallel also for a national certificate. Obviously always with the requirement of jurisdiction in case it is a judicial national certificate. But if these national certificates are issued, they can qualify under the regulation either as decisions or as authentic instruments, but they could also just qualify as private documents. So if they're just private documents, they cannot circulate according to the regulation. They will be able to circulate according to the law of the single member states or just because of factual recognition. Actually, there is a lot of factual recognition in this area, which we do not exactly know of, but many offices, many banks, and so on would just accept a foreign document without that being or without any requirement for that purpose, obviously on its own risk. So we see it can be either, a national certificate can either qualify as a decision or as an authentic instrument. And now we need to find out when is such a national certificate actually a decision according to the regulation, and that is a big question. And I want to mention already here that all what I say is one interpretation of it. We have no certainty in this area. There are a lot of opinions, but there is no certainty yet. The European Court of Justice will need to give us certainty on these points, but I will try one interpretation which I think is quite compelling. Decisions, in front of all, according to Article 3, paragraph 1, letter G, are decisions in matter of succession given by a court. So what we need to know is what is a court. And courts are defined by Article 3, paragraph 2. So you see all the requirements for a court. So what is a court actually? There are two notions of court. There is a court in the institutional sense of the word. So you think of a court as being an authority, part of the judicial system of a member state. That is the court in institutional terms, and there is absolutely no doubt that all these authorities that form part of the judicial system of a member state are courts in the meaning of the regulation. Absolutely no doubt. The only question is whether all measures that these courts take can also be qualified as decisions, because that is not entirely clear. There are certain measures, in Oberle, the European Court of Justice referred to this, that may not be qualified as decisions. So what can we say? In general, yes, measures taken by courts are decisions. That is the default rule. But exceptionally, these measures cannot qualify as decisions, like, for example, if you go to a court and make a declaration of acceptance or of waiver of an inheritance, then the court does nothing else but record your declaration, so it does not exercise judicial activity. And since it does not exercise judicial activity in this case, this measure cannot be considered as a judicial decision. Also, this is said by the European Court of Justice. So what can we say? If a court or if an authority is part of the judicial system of a member state, then it qualifies as a court, and that automatically means it is subject to the rules and jurisdiction according to the regulation. That in any case, whether then, as a consequence, all measures are to be qualified as decisions cannot be said. Basically, we can say, whenever this court exercises judicial function, then the measure will also be a decision. But if it does not, if it just records declarations like acceptance and so on, then it is not a decision. It may be and will generally be an authentic instrument. This is the court in institutional terms. What is more difficult is the court in functional terms, because the meaning of court under the regulation is very broad. It is not just an authority forming part of the national judicial system, but it can be also another authority or legal profession with competence in matters of succession, which exercises judicial functions, or is a court commissioner, or acts under the control of a judicial authority. What does it mean to exercise judicial function? According to the European Court of Justice, that means to have the power to decide a legal dispute, to rule on its own motion on possible points of contention. And an authority is not a court if it acts dependent on the will of the parties. So if it acts only by request of the parties and does not anything else, especially does not solve any legal dispute, it cannot be considered as a court. Whether an authority has been communicated to the European Commission as being a court under the regulation or not is completely irrelevant for qualifying it as such, as the European Court of Justice has reminded us. So here again, you can see what court means in this overview. So we have the institutional meaning. You remember, an authority being part of the judicial system is in any case a court, and thus in any case subject to the rules on jurisdiction. Whether all measures are decisions or not is questionable. In any case, those where the court exercises judicial activity, it is clearly a decision. And then you have the functional meaning. In the case of a functional meaning, you have court commissioners and authorities acting under the control of a judicial authority. These are considered to be courts with no further requirements, and authorities and legal professionals that exercise judicial function without any control by judicial authorities are also to be considered courts, but they need to have a power to decide legal disputes. So where do notaries fit in here in this system? In many legal systems, actually, notaries are court commissioners, as we've heard from Professor Wautelet, and that means they are courts in functional terms. But in most legal systems in Europe, they're just authorities with no judicial function. So they would not fit into the concept of courts. This is what the European Court of Justice said with regard to Polish notaries when they issue a certificate. And this is what the European Court of Justice said with regard to Lithuanian notaries. The court said, except where the notaries in Lithuania act as court commissioners or under the control of a judicial authority, they are to be considered not courts. So except in that case, in those cases, and the Supreme Court in Lithuania said, no, our notaries do not act under the control of a judicial authority. They are not court commissioners, so they are not courts under the regulation. And this means that they are not subject to the rules on jurisdiction, which only apply for courts. So what can we say? When are national certificates decisions? If they are issued by a court in institutional terms, which exercises judicial functions, if they are issued by a court commissioner, by an authority under the control of a judicial authority, or by an authority or legal professional who exercises judicial functions, then this is a decision. And it is irrelevant whether this decision is issued in contentious or non-contentious matter. It is irrelevant whether these decisions, these certificates, acquire the force of res judicata, and it is also irrelevant whether they are enforceable or not. So this also completely changes the concept of decision, which we have known so far from other regulations. It seems as if the concept of decision, according to the succession regulation, is completely different from other concepts of decision in other regulations, and that is actually very puzzling, and it is also understandable why we are fighting on this concept, because we have a certain image of what it is supposed to mean, and now we get to this notion which is so broad and does not compare with notions that we know of. So according to this very broad concept of decision, which national certificates can be qualified, could be qualified, I need to say, because we do not know. I really want to say here, we do not know, but which could be qualified as decisions? Well, for certain, the Austrian Einantwortungsbeschluss, there is no doubt. Basically, there is no doubt on that. Even the critics in Germany who would generally say, no, the certificate in Germany is not a decision, they would still say the Austrian Einantwortungsbeschluss is a decision under the regulation. With regard to the German Erbschein, we have the German position, so the majoritarian view in Germany says it is not a decision, it is an authentic instrument, but it seems that this follows this narrow notion of the concept of decision. If we have a larger notion of the concept of decision, I think it is clear that the court in these cases exercises judicial function, and therefore it could be qualified as a decision as well. And the same is true for the Greek certificate, which I cannot read, but some in the room or also in the virtual space will be able to read. We have additional certificates of this kind in France. If you recall the case of Oberle, Mr. Oberle applied for a certificate in France, in Alsace-Moselle, where there is a certificat d'hérédité, which is very similar, issued by a court, very similar to the German Erbschein. And we have a similar certificate also in those regions in Italy where there is still the Austro-Hungarian register in place, because even there the court issues a certificato di eredità. Then we have all those national certificates which are issued by court commissioners, like in Croatia, in the Czech Republic, but also in Slovakia. And since they are issued by court commissioners, we can draw the conclusion that even these certificates are to be qualified as decisions. Which national certificates are to be qualified as authentic instruments? We see that if they do not qualify as a decision, they could at least qualify as an authentic instrument. We have a definition of authentic instruments in Article 3, paragraph 1. It is important to know that if there is only an authentic instrument, the effects in other member states are just evidentiary effects on single factual elements, like the wording of the declaration, the personal details and identity of the declaring persons, time and place. But what about the content? There is absolutely no binding force with regard to the content of authentic instruments. So the fact that they can travel is very, very limited. What travels actually across member states are just the evidentiary effects, so it is almost almost useless in other member states, this type of certificate, because at least under the regulation it cannot produce full force. What we can say, obviously, the member states could take such an authentic instrument as fully applicable also with regard to its content, so also accept its effects, but the regulation does not provide for this. So we can say there is an authentic instrument if it is issued by a legal professional or authority that has the power to establish authenticity, does not exercise judicial functions, and acts without a delegation by a judicial authority. Examples are, as we know from the European Court of Justice, the Polish certificate or the Lithuanian certificate, but also the French notarial acte de notoriété, the Dutch Verklaring van Erfrecht, and the Portuguese Habilitação de Herdeiros. So the picture that we get is very puzzling. Because what does this mean? We have decisions, we have authentic instruments, and what does it depend on? It depends on the law of the member states. The member states actually say whether it is a court or it is another authority that issues it, whether it is in a judicial proceeding or not, where it is issued. So the effects of these national certificates depend on the law of the member states, whether they can be recognized as decisions or as authentic instruments. What I have not talked about so far is what does it mean if a national certificate is a decision? What kind of effects are produced in the other member state? And this, again, is not clear. There are those who sustain they must have the same effect as in the country of origin. And I tend to agree with that. But then there are those who say only procedural effects can be produced in other member states. So that would mean they have a very, very limited effect. So they would be relevant in other court proceedings in other member states as an incidental question. They would have solved the incidental question. If there is the question, who is the heir, they would take this decision as already being decided. But I think seeing this in such a restrictive way, that would just completely make these national certificates in a circulation irrelevant. So it is, I think, more convincing to consider these national certificates, if they are recognized as decisions, to produce the same effects in the member state of destination as in the member state where they were issued. So you see, the European certificate is an optional instrument, and we have traveling or circulating national certificates, and what this leads to is clear. It leads to possible conflicts. Conflicts between national certificates, conflicts between European certificates of succession, national certificates, and it also leads to conflicts between two or more European certificates. Let's first start with the conflicts between national certificates, and obviously we've heard can be decisions or authentic instruments. What are the possible conflicts? There can be conflict between two decisions, there can be a conflict between a decision and an authentic instrument, and there can be a conflict also between two authentic instruments. Let's start with the conflict between two decisions. Basically, the European regulation tries to avoid these conflicts. First of all, by applying the same rules of jurisdiction. So if you have a judicial certificate from any member state, this court that issues this certificate needs to obey by the rules of jurisdiction of the regulation. This is what Oberle said. And you also have Article 17 and 18, lis pendens and related actions rule, that also applies. So also this tries to avoid that two judicial national certificates can be issued at the same time, and still it will happen. And if it happens, we have Article 40, letter C, that says if there is a decision between the same party, that conflicts with an internal decision, the decision coming from outside does not need to be recognized. There is a ground of non-recognition in this case. What does this mean? We have a decision, for example, in one member state and a decision in another member state where they both produce their effects, but they would not produce their effects in the other member state. So in the end, we have a fragmentation because the succession is ruled according to one law in one member state and according to another law in another member state, and this is clearly against the goal of the regulation. And if two conflicting national certificates, which are decisions, are presented to a third member state, the rule of priority applies according to Article 40D. So the first decision that is presented is recognized, the second is not. But it is important to take into consideration that the effects of these decisions in the member states where they were issued remain. What happens in a case of conflict between a decision and an authentic instrument? Well, if they are presented in another member state, we need to remember authentic instruments only have evidentiary effects. So if the decision can be recognized in an other state, the decision will prevail over the authentic instrument, but this is only the simple case. Think of a member state that issues a national certificate, and it is, under the regulation, an authentic instrument. And then there comes a decision from outside. So a national certificate qualified as a decision from outside. You have in your member state your own national certificate, which is an authentic instrument, and then there comes this decision from outside. What do? Which one prevails? Is it the decision recognized under the regulation, or is it your certificate? We don't know. We have no solution for this. Maybe the best solution would be to say, well, in this case, we cannot believe neither in the one nor in the other, so they extinguish reciprocally their effects, and we need to just clear the situation. It must be cleared in some way, but we cannot believe nor in the one nor in the other. Or we could say, well, in this case, we follow our own certificate, but that will be difficult since Article 40 letter C only allows us to not recognize a foreign decision if we have an internal decision. But in that case, it's just an authentic instrument, so we cannot not recognize the foreign decision. And then it depends what are the effects of recognition of a decision. If you see it like me, like very broadly, you have a real conflict, and you will have to solve it basically either on the basis of saying, well, they extinguish each other's effects, or even saying the decision prevails over the own national certificate. We just don't know. Everything is possible. What happens in case of a conflict between two authentic instruments? Well, if they are presented to a third country, that typically does not constitute any problem because obviously the content does not travel, only evidentiary effects. And if you have doubts on the content of an authentic instrument, this can be challenged in front of the court that have jurisdiction under the regulation, and this court will then decide, so the decision travels according to Article 39. The regulation talks about the conflict between authentic instruments and says, well, in this case, you need to decide according to the circumstances. That would be the case if you have your own authentic instrument, another authentic instrument comes from outside, then you need to decide according to the circumstances which one of the two can prevail. But I would want to remind you that the foreign authentic instrument only produces evidentiary effects, so it's clear that the national authentic instrument in that case will prevail because the content actually is fully effective in the member state where this authentic instrument was issued. So let's now pass on to possible conflicts between the European certificate and the national certificate. There are possible cases of conflict, of course, because you can think of a member state where the court issues the European Certificate of Succession and comes to the conclusion, well, the last habitual residence was in our country. Like, for example, Germany says, well, this was clearly in our country. And at the same time, in another member state, the courts come to the conclusion, no, it's in our country. It's clearly in our country. So it could be that you have two European certificates of succession in this case, or you could have one European certificate and a national certificate. The regulation, again, tries to prevent this by uniform rules on jurisdiction, by an information duty that is burned or is the burden of the applicant for the European Certificate of Succession needs to tell the authority that there is already a proceeding in another member state. But also a second proceeding can be stayed according to Article 18. And another possibility is that you may even deny the issuance of a European certificate if it is conflicting with a decision recognized under Article 39. So if you have already a decision, like a certificate that can be qualified as a decision from another member state recognized in your member state, you can deny issuing a conflicting European Certificate of Succession. But the conflict can arise nonetheless. And in this case, we need to know that the European Certificate of Succession has no general priority over national certificates. Actually, there is absolutely no hierarchy. The European certificate is just an optional instrument. It may be withdrawn, it may be modified, so the conflict is solved. But if it is not withdrawn, if it is not modified, the majoritarian view is that in case of this perplexity of situation, the effects, presumption of accuracy and legitimizing effect cancel each other out. What remains is just the public faith effect. Third parties may continue to rely on the European Certificate of Succession unless they know or are grossly negligently ignorant of the inaccuracy of the certificate they rely on. But what does gross negligence in such a case mean? If you know that there is another national certificate that is in conflict with the European certificate, are you already grossly negligent in relying on the European Certificate of Succession? I would say no. And that is also, I think, the majoritarian view. But you have some obligation to investigate, to try to find out why is there a conflict, and is the European certificate accurate or not. Just we don't know what this duty actually means, how much you need to do in order not to lose your protection under Article 69. Lastly, and this is the final point, what happens if there are two European certificates of succession that are in conflict with each other? Well, we know the regulation wants us to have only one European certificate. So in this case, it is clear none of the two can produce the effects under Article 69, except for the public faith effect, which will continue and which will be destroyed. So the good faith of third parties will be destroyed only in case there is knowledge of the other European Certificate of Succession, or in case one grossly negligently does not know about the other European Certificate of Succession. So what can we say in the end? We can say that there are a lot of questions, but almost no answers. So if you expected me to give you real good answers, I cannot serve you. I cannot serve you because the European Court of Justice will need to tell us. What we can say is that the problem is real, and the regulation should actually address this problem in the future. If there are changes, the conflict between national certificates and European Certificate of Succession, and also between the national certificates, should actually be dealt with either in the first part where there are the considerations or recitals, or also in the legal text. But I would say at least in the recitals it should be addressed. What could also help evidently is a register, be it a uniform register, but as we've heard, the MAPE project does not prefer a uniform register, rather registers in member states that are interconnected. In the end, it's one register for all, because all data get together somewhere. That would already serve the purpose, because you could register there not only European certificates, but also national certificates. So you would know for any single case whether there is already one of those certificates or not. But some conflicts will just not be avoidable, not even by this register. So we will have to deal with these problems, and if we had some more solutions in the text of the regulation, be it in the recitals or in the normative text, that would certainly help. Otherwise, the European Court of Justice will need to help us. Thank you very much for your attention. Okay.
Thank you so much, Professor Christandl, for this really inspiring and interesting presentation. I'm very honored to be here and just to moderate the following panel with those highly qualified panelists we have for you. And first of all, I want to introduce them a little, although you know them, I'm sure. And so we have for the panel Paolo Pasqualis, former president of the CNUE and a really good person as far as the succession regulation is concerned. A fan of the succession regulation, I might say, and very much deep in the international private law. We then have my dear colleague from Spain, Isidoro Calvo Vidal, who is also a great commentator of the succession regulation. He wrote a commentary concerning mainly the ECS. And he's also occupied with digitalization in the notarial profession in Spain and has also further book and commentary projects. And I'm very glad to introduce him and to meet him here in Vienna. Then we have Tibor Szöcs from the Hungarian Notarial Institute. He is the president of this institute and also kind of intertwined with the succession regulation since a very long time. And of course we have Professor Christandl who will join the panel. As you've already heard, we have kind of an interplay not only of ECS and national instruments, but also to deal with national decisions, authentic instruments, and ECSs, and sometimes not just according to the Highlander principle with one of them, but with a multitude of them, with parallel proceedings in different member states. And so Professor Christandl gave us a bunch of questions, a kind of a kaleidoscope for this panel discussion. And we will have 5 minutes. Oh, sorry, I forgot to to welcome you online. Pascal Redliff, please excuse my mistake. I just saw you and said, well, we have a lady watching us. No, we have a further panelist, Pascal Redliff from Belgium, and she will make a contribution too. We have kind of 5 minutes for each panelist, and they will present you their view of the questions concerning if there are national certificates in their country, how they qualify under the succession regulation, if national certificates from other member states create any problems in the clash of several instruments, or if they are easily accepted, and also if there are conflicts of certificates, and of course if there are any solutions. You've already seen we do not have many answers, but we have questions, and so perhaps this panel will contribute to deliver some answers. I want, because the topic is very interesting, just not to take your fundamental right of a coffee break from you, but we've decided to cut it down a little so that we have a little more time for this discussion. I'm expecting to be very fruitful. So perhaps, Paolo, you want to start?
Thank you. Don't know if It works. Yeah, it works. I heard. So thank you very much for this invitation, and congratulations for the brilliant presentation given by Professor Christandl that has focused for us all some concerns about the functioning of the circulation of the certificates, with some questions. Just from the Italian point of view, probably you know that, as it has already been said, in Italy the certificate of inheritance exists only in very limited areas of the country, the areas of Südtirol, Trieste, Gorizia, some provinces of there, and essentially parts of the country once under sovereignty of the Austro-Hungarian Empire. And so in Italy, the problem of relationship between national certificates and European certificates arose only in those areas. And I dare say it has been brilliantly solved for the moment. So I had this short note that I resume here. The first point concerned the competence of notaries and judges for issuing an ECS in the areas where the national certificate were applicable. This uncertainty arose at the origin because of not clear, rule given by the Italian legislation and legislator, and has been clarified in the sense that even in those areas, the notaries only are competent in order to issue the European certificate of succession. It's maintained, obviously, the competence of the local judges in order to deliver, in order to issue the national certificates. The more interesting case, however, is the second case, and this is the question if an ECS can also be used in Italy for entry in the land register in those specific areas governed by the old system, let's say the ancient local system. And this case, after some uncertainties, some refusals by various land registry offices, and also in this case, the matter was brilliantly, in my opinion, solved by the registry judge of Trieste, who has a name and surname, Dr. Arturo Picciotto, who is a brilliant gentleman from Naples, who, while working in Trieste, fell in love with the Austro-Hungarian system, and with his decision of May 2019, he affirmed with an accurate and detailed motivation, structured almost like a decision of the European Court of Justice, with the same structure, a preamble giving local law, European law, facts, and so on. And at the end, he decided that an ECS offers, even an ECS obviously issued in Italy, for the purpose of it to be used abroad, in this case Slovenia, but also in the country of origin, of course. And so he said that the ECS gives the same guarantees of certainty and legality based on EU law, and so can be considered equivalent to those as a guarantees, as a safety, let's say, of the certificates issued by the National Land Register judge. And therefore an ECS must be accepted for registration in the land register also in those areas. And this solution has been accepted all over the country, let's say all over the other local land registers governed by the ancient rules. And so now I have here some examples printed here, obviously in Italian, unfortunately, and that all the local judges are aligned, let's say, on this solution, and so we can use easily ECS coming from abroad, but also Italian ECS issued for abroad but used in the country in order to register in front of the land registers in Trieste or in Südtirol or in the other areas. So I think this is a very useful, practical, and obviously acceptable, very acceptable solutions that allows the circulation in Italy of the ECS coming from abroad and also obviously the national ECS inside the country, as provided obviously by the regulation. I don't know if I have, no, I haven't, of course, used the 5 minutes. No, I had here some questions given by the professor that I'm perfectly in condition to answer it, but maybe later on. Thank you.
Okay, thank you very much, Paolo, and thank you very much for mentioning this decision we are all interested in. And so, Isidoro, would you just continue, please?
Thank you. Thank you very much. Thank you for your presence. Thank you, the Austrian Notariat, for the invitation to participate in this event. Spanish succession law had not established never a certificate or document of content effects similar to those of the ECS. In our practice, nevertheless, we receive the national certificates from or documents from other countries. Everything from Germany, acte de notoriété from France. As many investors have properties in Spain after his death, notaries in Spain have used these documents, and nowadays we use the ECS to demonstrate the status and the rights of heirs, the attribution of a specific asset, or the powers of a person who have to execute the will or administrate the estate. Nevertheless, these documents are not essential in our succession proceedings, and Spanish notary can decide directly whom the heirs are in accordance with the applicable substantive law, taking into account directly other documents. If under Spanish legislation we don't have this type of certificate, in order to demonstrate the condition of heirs or legatees, these documents essentials are the certificate of death, the certificate of the last will of the register of last will of testaments, and the copy of the testament of the notarial declaration of intestate wills. But actually, under Spanish legislation, in fact, these documents determine the persons who have the right to become heirs, legatees, or administrators, because all of these conditions need the acceptance of these persons called to the succession by testament or by law. And these declarations normally are made also in an authentic notarial instrument. In my practical experience, I can tell you that sometimes I was claimed to issue a kind of document or certificate as a foreign model, and I accept this claim, and I issue in according our notarial regulation about a specific regulation about the acts of certification of commonly known facts. It's like an acte de notoriété, the French acte de notoriété, that I consider I can issue under my regulation, and it has been issued in the foreign country with success.
Okay, thank you very much for your contribution, Isidoro. And now we have next in line Tibor Search. He will talk in German. And for Hungary. Geht's?
Vielen Dank. Wenn es kein Problem ist, würde ich Deutsch sprechen. Also ich bedanke mich auch recht herzlich für die Teilnahmemöglichkeit, für die Einladung, und bedanke mich auch für die fantastische Präsentation von Herrn Professor. Ich möchte die von Herrn Professor gestellten Diskussionsfragen aus ungarischer Sicht zu beantworten. Also erste Frage, Erbnachweise nach dem nationale Erbnachweise nach dem ungarischen Recht und deren Rechtsnatur und Rechtswirkungen. Auszugehen ist davon, dass das ungarische Recht ein umfassendes, justizförmiges Nachlassverfahren kennt. Aber ein Vorbild dafür war das österreichische Verlassenschaftsverfahren. Und es handelt sich hierbei also um ein außerstreitiges, gerichtsähnliches, quasi gerichtliches Verfahren, das in Ungarn vom Notar durchgeführt wird. Ein wichtiger Unterschied zum österreichischen System ist, dass der Notar nicht als Gerichtskommissär tätig ist, sondern die Befugnisse des Nachlassgerichtes, des Gerichtes ex lege ausübt. Und das Verfahren wird ebenso wie in Österreich mit einem förmlichen Beschluss beendet. In Ungarn ist es der sogenannte Beschluss über die Nachlassübergabe. Das ist etwa vergleichbar mit dem österreichischen Einantwortungsbeschluss. Im Rechtsverkehr hat es im ungarischen Recht etwa die gleichen Funktionen wie der Einantwortungsbeschluss in Österreich oder wie etwa ein Erbschein nach dem deutschen Recht. Also es hat die Funktion, dieser Beschluss hat die Funktion, die Erbfolge amtlich nachzuweisen gegenüber Dritten sowie vor den unterschiedlichen Behörden. Außerdem entfaltet dieser Beschluss, Nachlassübergabebeschluss nach dem ungarischen Recht eine Legitimationswirkung. Also das ist ein gültiger Rechtstitel für die Eintragung in den unterschiedlichen öffentlichen Registern und auch Drittschutzwirkungen stehen diesem Beschluss zu. Was die Rechtsnatur dieses Nachlassübergabebeschlusses im System der europäischen Erbrechtsverordnung betrifft, also ich bin der Meinung, dass dieser Beschluss eindeutig als eine Entscheidung qualifiziert werden kann. Dieser Beschluss wird ja, wie ich schon gesagt habe, als Ergebnis eines justizförmigen Verfahrens erlassen, wo die Befugnisse des Nachlassgerichts vom Notar ausgeübt wird und gegen diesen Beschluss ist auch eine Berufung statthaft. Für das allfällige Berufungsverfahren ist das Landgericht zuständig. Also kurz und gut, wie ich gesagt habe, handelt es sich praktisch um eine Entscheidung und ich glaube, dass solche ungarische Nachlassübergabeentscheidungen als ungarische nationale Erbnachweise unterliegen dem Anerkennungssystem gemäß Kapitel 4 der Verordnung. Zweiter Fragenkreis, was Herr Professor erörtert hat, ist ausländische Erbnachweise in Ungarn. Das ist ziemlich schwierig, diese Frage zu beantworten, zumindest aus Sicht der ungarischen Notariat. Der Grund dafür ist, dass die ungarischen Notare praktisch nichts zu tun haben mit ausländischen Erbnachweisen. Also keine ungarische notarielle Mitwirkung ist nötig, wenn jemand einen ausländischen Erbnachweis in Ungarn geltend machen möchte. Das muss unmittelbar bei der Registerbehörde oder bei einer dritten Person, zum Beispiel vor einer Bank, vorgelegt werden. Also tiefgreifende Erfahrungen haben wir diesbezüglich nicht. Nach meiner informellen Kenntnisse verlangen allerdings zumindest die ungarischen Grundbuchämter in der Regel die Vorlage eines europäischen Nachlasszeugnisses. Der Grund dafür besteht darin, meiner Meinung nach, dass für die Eintragung aufgrund eines europäischen Nachlasszeugnisses klare Regeln im Grundbuchordnung vorgesehen sind. Über die Eintragung aufgrund eines ausländischen Erbnachweises schweigt dagegen das Gesetz. Dritter Fragenkreis ist etwa die Verwendung der nationalen Erbnachweise in die umgekehrte Richtung, also Verwendung von ungarischen Erbnachweisen im Ausland. Auszugehen ist davon, dass es in Ungarn relativ viele europäische Nachlasszeugnisse ausgestellt werden. Im letzten Jahr 2022 wurde, soviel ich weiß, mehr als 250 europäische Nachlasszeugnisse erteilt. Das ist eine relativ große Anzahl im Verhältnis zur Bevölkerungszahl von Ungarn. Und Ich glaube, das ist ein starker Anhaltspunkt dafür, dass die Verwendung von ungarischen nationalen Erbnachweise, also die Verwendung der notariellen Nachlassübergabebeschlüsse in den anderen Mitgliedstaaten oft auf Schwierigkeiten stößt. In einigen Fällen bekommen wir Rückmeldungen, auch von den ungarischen Notaren, wonach der notarielle Entscheidung, der notarielle Beschluss in einem anderen Mitgliedstaat nicht angenommen wurde und deshalb die Partei gezwungen wurde, ein europäisches Nachlasszeugnis zu beantragen. Dies ist der Fall zum Beispiel auch in Österreich. Also wie bekannt, relativ viele Ungarn haben Bankvermögen in österreichischen Banken, aber auch in den sonstigen Mitgliedstaaten der Eurozone, in der Slowakei, in Deutschland. Und in der Regel beharren die ausländischen Banken darauf, ein europäisches Nachlasszeugnis vorzulegen. Gewissermaßen kann ich allerdings diese Praxis verstehen. Also wie bekannt, der europäische Nachlasszeugnis entfaltet eine einheitliche Rechtswirkung, insbesondere eine einheitliche Drittschutzwirkung und möglicherweise haben die Banken einen größeren Grad von Sicherheitsgefühl, wenn sie ein europäisches Nachlasszeugnis bekommen. Dankeschön.
Vielen Dank, Tibor Közbenyer. Last but not least, our guardian angel directly from Brussels, from the heart of the succession regulation. And the floor is yours, Pascal.
Thank you very much. Thank you for inviting me to participate in the panel. I will try to answer the questions from the point of view of Belgian notarial practice. First, I will try to describe briefly our national certificate in Belgian law. It is called acte d'hérédité or certificat d'hérédité in French. It is usually issued by a notary. However, in simple cases, meaning a legal devolution, no will, no minor children, it can be issued by a civil servant from the administration for patrimonial documentation. It is issued when required by any legal heir, legatee, executor, or administrator. It allows them to prove their status and their rights in a succession, and especially to obtain the release of the assets. It is interesting to point out that the provision of Belgian law regarding the acte d'hérédité were recently amended by successive reforms of the Civil Code in 2022. They can now be found in Article 4.59 of the Code, whose latest amendments entered into force last April. The law now gives more probatory effect, in French we say force probante, to the certificate, specifying that the persons mentioned in it as heir or legatees are deemed to have this status and to be able to exercise the rights and powers attached hereto. Third party acting bona fide with these persons are therefore legally protected. I think that the effects are now very similar to those of the ECS as described by Professor Christandl. Another innovation in Belgian law regarding its national certificate is that such documents should now mention any transfer of immovable property by death, if applicable, in order for such transfer to be recorded in a land register. Until now, only transfer inter vivos, like sales contracts or gifts, were recorded, as well as mortgages and other charges. Secondly, it seems that being issued by a notary, the Belgian certificate of succession can be considered as an authentic instrument, both internally and under the EU regulation. As such, it should benefit from the rules regarding circulation of such instrument in member states, especially acceptance. In practice, we have seen cases where Belgian certificate of succession was used for the release of bank assets situated in another state. Problems arising were about translation and sometimes a request for apostille, even if not legally required, but in general, it seems to work. It is also possible to imagine the opposite, a national certificate from another member state being presented in Belgium for the release of bank assets. Again, problems of translation may arise, but as long as the foreign certificate is an authentic deed or a court decision in the sense of the regulation, acceptance or recognition shouldn't be a problem in Belgium. My next point was to say that in practice, the use of the ECS seems to be more frequent now than it was within the first years of application of the regulation, when people were often still asking for national certificates. Professor Watley has already commented on that earlier. In Belgium, 312 ECS were issued during the year 2021. It may seem little compared to the 57,500 national certificates issued during the same year, but I think that it reflects the fact that only a relatively small percentage of all cases are international, and even in those cases, ECS is useful mainly if there are some assets in another member state. I have practical examples of using it in order to release bank assets from Spain, Italy, Sweden, and to record transfer of property in Italy. I must admit that I didn't know what formalities the Italian colleague had to carry out when he received the ECS he had requested from us, but I knew the property had been successfully recorded in the name of his client. After listening to Maître Pasqualis, I know that now what happens in Italy. My colleagues and I have also noticed that Belgian banks and insurance companies now seem more willing to accept a European certificate in order to release the assets, be it ECS issued by a Belgian notary or an ECS from abroad. However, as discussed this morning as well, local obligations regarding the notification to the tax authorities in particular still have to be respected. Moreover, in some cases, it remains more appropriate to issue a national certificate. For example, in a matter of urgency, when it is urgent to release Belgian assets, or because a certificate may be requested by law, for example, to file a request for envoi en possession in front of a Belgian court. My fourth point is about the transfer of property, to record the transfer of property in Belgium. Personally, I've not had the case yet of receiving a European certificate issued in another member state, and I've not heard of such case. I think we're not sure at the moment of how this will be dealt with in practice, given the present requirement of internal Belgian law regarding entries in the land registry.
Pascal, excuse me,
yeah.
We have to just look a bit about the time.
Just as a short, the solution seems to be that we will have to issue a Belgian deed and attach the certificate to it in order to register the transfer of property. And that was what I wanted to say. Thank you very much.
Thank you very much to all of you for those valuable and useful contributions.